Karen is a pejorative slang term for an obnoxious, angry, entitled, and often racist middle-aged white woman who uses her privilege to get her way or police other people's behaviors. However, Karens come in all shapes and sizes and can be any ethnicity, nationality, race, sex, gender, sexual orientation, or political affiliation.
Come to the dark side.
Ha, Karen!
Welcome back to What the Hell, Karen? A weekly satirical take on Karen and the entire Karen family. Today, Karen's niece on her sister's side, you know, the one who was pulled over a few weeks ago that hung the Moorish American flag out of her car? Yeah, that one. Well, she had no clue that not accepting a traffic ticket didn't mean that one didn't exist, and she has her day in court.
Keisha Johnson. Keisha Johnson. Come on up here, ma'am.
I would like to stand here.
No, you got to come stand at this podium.
Awesome.
I
Can you
get
tell me what
Man, we have to come up here. We can't.
laws you guys operate under?
the laws of the state of Kentucky.
Oh, yes. As in like anti laws, laws, that sort.
Come up here and stand at this podium. I have to get you on the record so that so that we can see you with your argument.
Okay, well, for on the record, I reserve my right to be called crossing the thing.
I'm going to bring her up here.
No. All right, and now, do you have a lawyer?
No.
It looks like somebody named Klein.
You guys appointed it to me.
No, nobody appointed it to you. Klein was somebody who, let me look at this, Miss Johnson. No, I don't think so. Let me look. Dale Warren was once your lawyer. You know Dale Warren?
Once is no longer.
Okay.
Came in earlier and wanted to be his name stricken from that record.
All right. So you want to represent yourself. Is that true, Miss Johnson?
Actually, I would like to know what law you guys operate under in court.
Okay. Well, Miss Johnson, I really don't want to create some big scene.
Okay, well,
Hang on for a second. I do not want to lock you up, but I may very well have to. I need for you to come up here and stand at this podium.
can I just sit here?
No, you cannot. No, you cannot. You have to come up here and stand at this podium.
Okay, can you put it on the record that I'm reserving my rights as I cross this bitch?
Yes. What, Miss Johnson?
Turn your phone on. Put your phone. Turn your phone on. Put it in.
I need to know what you're doing, Miss Johnson. I need you to stand at this podium.
Put it in your pocket. Put it in your pocket. Put it where we can't see.
All right. Next up, Chris.
Where it's not.
Show me the law. Show me the law.
This is my property. Show me the law.
All right.
Show me the law.
Chris.
Show me the law.
Chris.
Show me the law.
Go ahead and lock her up. Go ahead and take her into custody.
No. You're being very forceful.
You guys see this? Ow! What are you doing? There's no right. You have no right.
Just sit over there. Nothing's going to happen.
I mean, anybody, you have no right. For what? What is this for? Are you guys watching this? Under the Constitution, you have no right. No right for that.
Yeah, I'm not finished with her yet.
What are her charges? I'm sorry, she's not. Like her and abusing her.
No, I'm not okay.
All right.
What are her charges? I'm sorry.
Come up here and stand at this podium, Miss Johnson.
I'm sitting here because I'm an inspector of common law.
Okay.
And
So you're refusing to come here and stand in front of the bench. Is that true?
no, I reserve my rights, correct?
And that's fine, but come up here and stand at this podium. All right, first I want to talk about you and your case. All right, so you are charged with,
Another deputy up here to help.
my panic button doesn't work there, by the way. Anyway, you're charged with possession of marijuana, tampering with physical evidence, and possession of drug paraphernalia.
I don't understand any of that.
All right. Well, you're charged with illegally possessing marijuana.
Yes, I can.
You are charged with tampering with physical evidence and possession of drug paraphernalia.
I don't understand any of the charges.
Well, there's not a whole lot more. There's not a whole lot more I can do to try to explain to you.
Okay, let's start here. Can you guys prove jurisdiction? Prove jurisdiction, because I come in under common law. Prove your jurisdiction, that you have jurisdiction over me. Prove jurisdiction. A court cannot proceed until you guys prove jurisdiction. Show me your jurisdiction. Show me your law.
All right. All of our laws are codified in the Kentucky Revised Statute.
Show me jurisdiction. Show me law.
Hey, there you go.
Okay, that doesn't prove that you have jurisdiction.
Okay, so what else? Now, there's a simple way for me to prove jurisdiction to you, and that would be for me to ask the deputy to take you into custody. I have absolute confidence that I have
I
jurisdiction.
have formal charges, like you take me.
You do have formal charges.
Formal charges would be a complaint against me and another individual.
No, it doesn't have. I don't need another individual.
That's a citation, correct? Or,
Okay.
That's not formal
All right.
charges.
All right. So, what do you want to do about your case today?
Prove jurisdiction to me.
I don't have to prove jurisdiction
Yes,
to you.
do. In
All
the
right.
law, it
I'm going to
says
prove
you have
jurisdiction to you right now. I'm going to ask the deputy to go ahead and take you into custody.
Under what charges?
Under
what charges?
you are disrupting my court. I don't know where these people are.
Stay back. On your back. Stop resisting. Stop resisting. Stop resisting. Stop.
I don't know.
Stop resisting. Now come on up. Use your hands.
All right, we're going to pass her case to tomorrow.
You guys have been mistreated and wrong under common law, under the United States Constitution. And if they keep doing this and let us get away
Turn your phone off over. Hey. Can't record.
While Karen's niece on her sister's side was having her day in court, her sovereign citizen brother was in traffic court for an arraignment of a traffic ticket and, for some reason, thinks he's on trial.
I have every intention on pleading guilty. I've actually got an unsigned plea. This is right here. I just had a couple of clarifications I need cleared up before I'm able to intelligently do so.
Okay, so all we can do is tell you what your three options are. We can't give you any other further advice or...
I'm not asking for advice, sir.
Okay, sir, what's your question?
Do I have the right to be informed of the cause and nature of the charges and proceedings against me here today?
That's what we're doing here today, sir. That's why she called you up here. This is an arraignment. An arraignment is where you enter a plea of guilty, not guilty, or no contingent.
Yes, sir. Was that a yes or a no?
Okay, I'm gonna have you sit down. You're talking to a court. This is no joke. You don't get to address me that way. I explained to you, you asked me, do you have a right to have your charges explained? I told you yes and explained to you what this proceeding was. If you don't like that answer, I'm sorry, but that's the answer. The answer is...
Well, sir,
no, do not cut me off. I'm explaining to you this is an arraignment. She's explaining to you you're charged with failure to obey a sign or control device. You can plead on that, you're not guilty, where you don't accept responsibility and you be set down for a trial. You can plead guilty where you accept responsibility, or you can plead nolo contendere where you say you do not fight the charges, you're not saying you're guilty, you're not saying you're not guilty. Okay? What's your next question?
well, sir, I appreciate all that information, but it still didn't answer my initial question.
What's your question, sir?
Do I have the right to be informed of the cause and nature of the proceedings and charges here against me today? Okay, thank you, sir. Am I presumed innocent of these charges here today?
Yes, sir, you are.
Am I presumed innocent of every element of these charges here today?
Yes, sir, you are.
Is jurisdiction an element?
Yes, sir, it is.
Am I presumed innocent of jurisdiction?
Yes, sir, you are.
And has the prosecution provided any evidence of factual evidence of jurisdiction before the court, yes or no?
No, sir, they haven't. And I'm gonna say because they're not required to at this time because this is not a trial. This is an arraignment. will you enter your plea after being informed of the charges that you face. So they don't have that responsibility. That responsibility kicks in when you do certain things and when certain things are required, which have not been triggered. Do you have any other questions for me, sir?
Well, I move to dismiss this case for lack of jurisdiction.
What cause are you citing lack of jurisdiction, sir?
Because the prosecution has not provided any factual evidence of jurisdiction.
They don't have to. This is not a trial. This is an arraignment.
So how do y'all even have jurisdiction to accept my plea if jurisdiction is not an issue right now?
Because, sir, this is an arraignment. You got a ticket by a Gwinnett County officer on September the 11th, 2020. So that creates the reason why you're in this court. That gives the court jurisdiction over this particular offense.
Ha, Karen! Surprise, surprise. Karen's nephew on her brother's side, who is also a sovereign citizen, is also having his day in Wisconsin Superior Court again.
Attorney out of this courtroom.
I'm denying that because what you have said here shows
You
that
are
you
in
have
violation.
no understanding.
You are in violation of my rights.
Laws.
The oath that you took, you're in violation of. I am demanding my Sixth Amendment right to go pro se, and I would like this attorney out of this courtroom.
I understand your request, and I respect that you think that you understand this process. Clearly,
You do
by
not
your
respect
remarks,
me, Your Honor.
you do not understand, and I am duty-bound to make sure that you understand before I allow you to go
I
pro se.
perfectly understand. We established that the last time I was here.
Well, clearly your remarks today suggest otherwise.
According to you,
uh,
not according to the law. We're
Mr.
talking about the law, we're talking about rights. We're not talking about what you think. We're talking about what is
Future,
right,
you can
fully
go ahead
mine.
And
That's what we're talking about here today, and that's what you're supposed to be talking about here today.
Mr. Luke, you may proceed.
Thank you. Judge, I had read the information in file 17 CF 1013. The information is comprised of 2 counts of fraud against a financial institution. I'm going to read those elements and I'll make the elections that are required that I think that fit the proof that the state has. Number 1, the defendant, Gregory Rael, obtained money owned by or under the custody or control of a financial institution. Financial institution means a bank or a credit union chartered under the laws of this state, another state or territory, or under the laws of the United States. Element number 2, the defendant, Gregory Rael, obtained by means of false pretenses or by use of any fraudulent scheme money or a monetary instrument. A person obtains money by means of false pretenses or by use of any fraudulent scheme when, with knowledge that it is false, and they act with intent to obtain money. And finally, it says if you're satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you're not so satisfied, you must find the defendant not guilty.
And that those elements are the elements that apply to both counts 1 and 2 in that information?
Yes, those would be elements that would fit for counts 1 and 2. The defendant's charged as a party to the crime, but I don't know that that's particularly relevant. He was a principal actor in this with the state's evidence will show that he was a principal actor.
Thank you. And then if you can read to Mr. Rael the information in the other file and then indicate the elements as the state intends to prove them.
All right.
I object.
I, John
object to
Woodruff,
these readings, Your Honor.
Assistant District Attorney for Brown County, Wisconsin.
No, you do not understand.
Ha, Karen! Back in court with Karen's nephew on her sister's side, he is trying a few tactics from the Sovereign Citizen's Handbook to get the traffic court to see the error of its ways and dismiss his traffic ticket.
Do you not see, show them a copy of the ticket, which you signed on September the 11th? Next question, sir. So your motion to dismiss is denied.
Well, I'm not able to intelligently enter a plea if evidence of jurisdiction is not present.
I
Or
showed you evidence of jurisdiction, sir. I showed
I mean-
you the ticket that you signed on September the 11th,
so
2020 of this year.
that ticket is what gives y'all jurisdiction?
It does, sir.
Could you show me where on the ticket it says that?
I don't have to show you all the tickets. Sir, read the bottom of the ticket, please. It states the law and it states the offense that he's been charged with. That is a violation of law in the state of Georgia. It is alleged to have occurred in Gwinnett County on September the 11th, 2020, which is the venue and the jurisdiction of that particular offense. So that is the jurisdiction and venue in which the law allows me to sit in judgment of this case. How would you like to plead, sir?
Sir, if this court doesn't have jurisdiction,
This court does have jurisdiction.
can you provide factual evidence of
I've just
that?
provided to you. Whether you want to accept it or not,
Sir,
that's irrelevant to me. I've provided.
on that ticket, I didn't see the word jurisdiction
You
anywhere.
don't have to see the word jurisdiction. There's nothing in the law that says that it has to explicitly say jurisdiction. I just cited you the reasons why I have jurisdiction. Anything else, sir?
I'm not able to intelligently enter a plea.
Well, I'm going to enter a plea of not guilty on your behalf and set this down for a trial date. That's my ruling. That's what I can do under the law. Sir, have you been to law school?
Sir,
Have you been to law school? Answer the question.
are you acting as my attorney, sir?
Excuse me?
You just entered a not guilty plea for me. Are you
Which I
acting?
can do under the law, because you're refusing to enter a plea.
If a plea is not able to be obtained, I told you I have every intention on pleading guilty if
Well,
jurisdiction
sir,
has been met.
Okay. Mr. Jones, I'm not gonna play this game with you. I'm not gonna play it with you. Either you're gonna enter a plea of not guilty, you're gonna enter a plea of guilty, or you're gonna enter a plea of nolo contendere. If you don't enter a plea, the law gives me, because you're not entering a plea, indicates not guilty. The law gives me the authority to enter the plea as the judge in this case, as a not guilty, and set it down for trial. That's the law, okay? Whether you agree with that law is irrelevant to me, sir. It is, it really is. It's irrelevant to me because I'm operating under so you refuse to enter a plea, is not guilty. That means you're presumed innocent. That means the county is going to have to bring their evidence here to show me beyond a reasonable doubt that you committed these offenses as alleged in this ticket on this date in the manner in which they set forth. That's where we're at. So you can keep doing this. I'm not gonna do this all day with you, but that's the ruling. If you don't wanna enter a plea, I will enter a plea of not guilty. We'll set this down for a trial, and we'll just see what the county's evidence is or is not.
Sir,
I'm not having that discussion, Mr. Jones, listen to me. I am not having that discussion. So if you continue to go down this road, you're dangerously getting into the point of being held in contempt by this court. So listen to me clearly, sir. I'm not stuttering. I'm not raising my voice. I'm talking to you very calmly. And I am urging you to listen to me and follow the direction in which the court has just given you. If you do not want to enter a plea, the court will enter a plea of not guilty, set this down for a trial. What is it that you want to do, sir?
Ha, Karen! Karen's nephew on her brother's side, despite his objection to the reading of the elements of the evidence that the state has against him, has the court overrule his objection and has those elements read out to the court.
Hereby inform the court that count 1, the above named defendant on or about Tuesday, October 10, 2017, in the city of Green Bay, Brown County, Wisconsin, did intentionally cause bodily harm to Dan Magnan, a law enforcement officer, without his consent, and at the time of the act, the defendant knew or should have known that Dan Magnan was a law enforcement officer, and the act was in response to any action taken by a law enforcement officer in an official capacity, contrary to section 940.203, parent 2, Wisconsin statutes, a class H felony. And upon conviction, the defendant may be fined not more than $10,000 or imprisoned not more than 6 years or both. Count 2, the above named defendant on or about Tuesday, October 10, 2017 in the city of Green Bay, Brown County, Wisconsin, did knowingly resist an officer while such officer was doing an act in an official capacity and with lawful authority, to wit, arresting him, contrary to section 946.41, parent 1, Wisconsin statutes, a Class A misdemeanor, and upon conviction, the defendant may be fined not more than $10,000 or imprisoned not more than 9 months or both. Count 3, the above named defendant, Gregory Real, on or about Tuesday, October 10, 2017 in the city of Green Bay, Brown County, Wisconsin, having been charged with a felony and having been released from custody under Chapter 969 Wisconsin statutes, did intentionally fail to comply with the terms of his bond, contrary to section 946.49, parent 1, parent B, Wisconsin statutes, a Class H felony, and upon conviction may be fined not more than $10,000 or imprisoned not more than 6 years or both. That's it.
Thank you. And if you can identify the elements for each of those offenses, please.
Yes. Well, I'm reading directly from 1240C, which is the pattern jury instruction for battery to a law enforcement officer. Element number 1, that the state must prove the defendant caused bodily harm to, in this case, Dan Magnan. Cause means that the defendant's conduct was a substantial factor in producing bodily harm. Bodily harm means physical pain or injury, illness, or any impairment of physical condition. Element number 2, Dan Magnan was a law enforcement officer.
The record should reflect, has stood quietly and appropriately during that time. He is accompanied by officers here today. Mr. Rael, have you heard the presentation that the state has made with respect to the information and to those elements?
I do not consent to the reading of those charges. The state's attorney, I would love the state's attorney to prove to me that he has legal authorization to even charge me with any crime. I've heard his gibberish, as you put it, and I would like to myself add for the record, I demand that all oral, verbal, written, signed contracts, law, etc., that I have entered into with this court, signed, spoken, be revoked, stricken from all records. I do not wish to enter any further any contracts, laws, statutes, rules, regulations, or codes orally, verbally, and or written with or without my knowledge doing these proceedings.
Yeah, sorry. I didn't get the rest of it because the deputy came up to me at this point and told me he was going to arrest me if I didn't put my phone away. So I didn't get the rest of it. It was pretty basic. He continued to ramble about how the court didn't have authority. It'd be interesting if that's how that worked, but I don't think that's how that works. And then he was taken away. But as you can see, sovereign citizenship is total BS. It doesn't work. The courts don't respect it. They don't listen to it. And you can't use it as a defense for committing a crime. You can't say, I am a law unto myself and be set free. Mr. Rael learned that, though I don't think he ever accepted it. Too bad for him.
Ha, Karen! Meanwhile, back at court with Karen's brother on her sister's side, he is trying to exert that he's a free man of the land and will not be detained, to which, of course, the judge is not having any of it.
Is it safe to speak?
Go right ahead, sir, as long as you're not going to sit here and say you're not, because you can keep saying you're not intelligently able to enter a plea, that's fine, but that's going to be the ruling of the court. So what is it you want to say, sir?
I'm just gonna be quiet because threatened me with contempt to be thrown
No,
in
I'm
jail.
threatening you with contempt if you continue to go down this road of telling me I don't have jurisdiction when I've explained to you that I do, and continue to say I haven't shown you that that I have jurisdiction when I've shown you that I do. So I'm not gonna keep going down it. This is not a game. This is not some parlor trick. This is a court of law that is to be taken very seriously. If you understood the law and made arguments that had some legal basis, then yeah, I would be happy to entertain that, but you're not. What you're doing is spouting things that have no basis in law, that are not correct, and I've explained to you several times, and you keep going down this road that you don't see jurisdiction. It doesn't have to be there, sir. I showed you the facts. Okay, the law is not as explicit as you think it is. There's no loophole that you can play here. So either you want to enter in a guilty, not guilty, or no contingent, or you can talk to Ms. Biggs and see if she will be willing to work this case out to you in a satisfactory manner. But that's what we're gonna do here, sir. Okay, so what is it you want to do, Mr. Jones?
I really just like to live with my freedom, sir.
Ms. Biggs, have you threatened him with jail time?
I have not, Judge.
Have I threatened him with jail time?
No, sir.
Has anybody in this courtroom said that Mr. Jones is gonna be detained or arrested other than him being contemptuous to the court?
No, sir.
Deputy, no one has threatened your freedom here, sir. You are making something out of this that is not. And I guess you're trying to entertain these people or trying to impress them with some knowledge that you think you have. But you are really testing my patience over something that does not need to be tested over. You are charged with a simple role violation. That's it. Nobody's threatening your liberty. Nobody's gonna take you into custody unless you choose to have yourself taken into custody by being contemptuous to the court. So look, I used to be a criminal defense lawyer for 20 years, where I represented people charged with murder, rape, child molestation, armed robbery, federal court, state court. I understand the whole nature of people's freedom. I sat with 18-year-olds that looked at double life. Mama's sitting there crying, and I'm fighting for them every day. So you are really irritating me because you're sitting up here with a traffic ticket trying to act like somebody's about to put you in jail for life, or this is some kind of capital case, because you want to impress someone or impress these people and waste everybody's time. Now, if you want a trial, you can have a trial. If you want to show how they don't have jurisdiction, then you could do that at a trial, but you cannot do that at an arraignment. Do you understand me?
We're clear on that, sir.
Have a seat, Mr. Jones. Since you're gonna waste everybody else's time, we're gonna get it.
Ha, Karen!